the order dated 29/2/2024 is accordingly modified to the said extent. आइए disclose करें.
Permission item 2, WPL 800 of 2022.
You give your appearance. You are for the petitioner?
Yes, sir.
You give your appearance. Yes, petitioner.
Item 2, WPL 800 of 2022.
Where is the petitioner? Passover. Passover will be taken up at 12 o'clock. आप notice board में लगा दीजिए.
Item 3, WPS 3620 of 2023.
Worship in this we have to file one supplementary counter affidavit wanting to correct of the writ petition. Whether he had made application and affidavit regarding his change of name. Why not we have filed it and it is admitted fact that he had made application and affidavit is also there on the record.
So his father had disclosed his alias name while in service long back, right? And as far as his mother is concerned, there is no dispute,
No.
right? You also do not dispute her identity, right? So you consider his grievance.
My lord, he may make representation. And
What representation? We pass a clear order on this.
My lord, but the problem is that what he will be submitting is educational certificate.
Everything subject to other qualifications and other criteria. But so far as discrepancy in the name is concerned, that will not be a ground for his rejection.
No, that will be.
That should be
That is
sufficient.
admitted.
Is there any impugned order in this case?
My lord, there is a new order in the writ petition.
Where is it? He is just seeking a direction.
We consider his case.
Otherwise, it is within time.
Otherwise, it is.
Who is the authority who will consider his grievance? Before whom the matter is pending? Deputy Commissioner, respond number 5.
My lord, he will be.
This writ petition has been filed for the following relief. It is the case of the petitioner that the father of the petitioner, namely Dipendra Kumar Mishra, was working on class 4 post as peon in road construction department Devghar, who died in harness on 28/8/2020, leaving behind his wife, namely Parthul Devi, and 2 sons, that is the petitioner, and one Rahul Shandyal. The death certificate of the father of the petitioner has been placed on record. The petitioner filed an application for grant of compassionate appointment on 25/3/2022 before the respondent number 8. And the required application in proper form was filed on 23/4/2022. The full stop. The respondent number 6 found certain discrepancies in the name of the father of the petitioner as Sudhir Mishra or Sudhir Kumar Mishra, on the educational certificate, whereas it was written as Dipendra Kumar Mishra on other certificates and some other documents, and consequently the documents were consequently the documents were returned. By letter number 452 dated 26/7/2022 to the respondent number 7 for proper inquiries and recommendation for age relaxation for appointment of the petitioner on compassionate ground, who in turn forwarded the same to respondent number 8 for correction of documents.
Lawsuit. Lawsuit inquiry has been conducted, your lawsuit. Page number 21, your lawsuit. Sorry.
I am allowing your petition. Do you have any objection to that? Sit down. The petitioner again submitted the entire documents in details on 10/4/2023 before the respondent number 8, along with all the supporting documents. And on account of discrepancies in connection with the name of his father in the educational qualification certificate, the petitioner was not, the case of the petitioner for grant of compassionate appointment was not being considered. Consequently, the petitioner submitted a detailed representation before respondent number 8 on 5/7/2023, stating that his late father, namely Dipendra Kumar Mishra, had already made an affidavit about his name by its serial number 81 dated 15/12/1995 and submitted the original before the authority concerned, in which it was clearly stated that he was known by both the names Sudhir Kumar Mishra and Dipendra Kumar Mishra, and such information was also published in the newspaper as public notice on 23/11/1998. It is further not in dispute that the mother of the petitioner, namely Partul Devi, is getting family pension of her late husband, Dipendra Kumar Mishra. The learned counsel for the, it is a case of the petitioner that late father of the petitioner had disclosed his alias name before the department as back as in the year 1985/1988 during his lifetime, and no objection was ever raised by the respondents in that connection, and consequently the name of the father of the petitioner, as is reflecting in the educational qualification certificates with the alias name of late father of the petitioner, cannot be a ground not to process the prayer for compassionate appointment of the petitioner. It has also been brought on record that so far as the identity of the mother of the petitioner, who is also receiving family pension, is not in dispute. An order dated 28/2/2024 was passed by this court May 20. Pursuant to order dated 28/2/2024, this aspect of the matter that the father of the petitioner had disclosed his alias name way back in the year 1995/1998 was recorded in order dated 28/2/2024, and the respondents, upon verification of the record, has filed a supplementary counter affidavit stating that after much efforts, the application and affidavit has been found in the office record. The application is dated 2/12/1998 and affidavit is dated 15/12/1995. But no corresponding entry was made in the service record, which is the reason why the objection was being raised in connection with the name of the father of the petitioner as recorded in his educational qualification. Upon perusal of the supplementary counter affidavit dated 11/3/2024, there is no doubt that late father of the petitioner had disclosed his alias name before the respondent, and therefore before the respondents, though no corresponding entry was made in his service records. The counsel for the respondents has submitted that even if the identity of the petitioner is taken to be the son of the deceased employee, then also the respondent number 5 has to consider the materials to assess the entitlement of the petitioner for grant of compassionate appointment, and therefore the matter be remitted to the respondent number 5 for further consideration. Right. After hearing the learned counsel for the parties and upon going through the materials on record, this court finds that the father of the petitioner, namely Dipendra Kumar Mishra, had made an affidavit by serial number 81 dated 15/12/1995 and had submitted the same before the respondents, disclosing his alias name during his lifetime. It is further not in dispute that the identity of the mother of the petitioner is not disputed by the respondents. The mother of the petitioner is getting family pension. However, no corresponding entry, no corresponding addition was made in the service record of the deceased father of the petitioner, but the same declaration and affidavit has been admittedly found in the records of the respondents. In view of the aforesaid facts and circumstances, this court is of the considered view that the name of the father as is appearing in the certificates of the petitioner as this court also finds that a police verification has also been done.
Yes, it was.
A police verification dated 4/3/2022 has also been done, and the same is in favor of the petitioner. In such circumstances, this court is of the considered view that the respondents that the claim for compassionate appointment of the petitioner cannot be declined on account of any dispute regarding his identity. So far as the entitlement of the petitioner for grant of compassionate appointment is concerned, other parameters and criteria are required to be considered by the respondent number 5 as per the applicable circulars, and for that purpose the petitioner shall appear before the respondent number 5 along with the writ records and a representation within a period of 1 month. In case there is a delay in correction of the order, I extend the time also. Right? We'll take care of that. Within a period of 1 month, upon filing of such application, the respondent number 5 is directed to consider the case of the petitioner regarding grant of compassionate appointment and pass a recent order in accordance with law as per applicable circular and guidelines of the state government within a period of 1 month from the date of such representation. The petitioner will be entitled for an opportunity of hearing by the respondent number 5 or the district establishment committee as the case may be. The recent order be communicated to the petitioner through speed post. If the petitioner is found entitled for compassionate appointment as per the recent order, the needful be done within a period of 1 month from the date of the recent order. District petition is accordingly disposed of. Kindly give your appearance.
Item 4, WPS 6688 of 2023.
Document request short transfer as CA council's item.
Who is your senior counsel? You are trying to reopen the issues which has already been concluded?
No, Your Lordship. We have said as we have stated in counter, we have said because that at that time Commissioner was the competent authority.
Please hold on.
So
Come
we
to
have
page
sent it
number.
for final approval.
Just
Your
a
Lordship.
moment.
Your
For
Lordship.
final approval or for
Grant
further?
for grant. Sorry, grant, Your Lordship.
No,
For grant of first SC.
that is not your stand in the contract.
Let me read.
You read it. You have not read it.
Your Lordship.
Read it since you have not read it.
Paragraph 10, 11, 12 may I read, Your Lordship? Yeah.
Counter affidavit dated.
Counter 1324, Your Lordship.
Read it, please.
Yes, sir. Paragraph 10 at page 6. The videosity is on the students and the petitioner already approached this court by filing WPS number 873, wherein order date 29/9/20 for setting aside the order date 1910 and entitled for all death come retired benefit on the last scale drawn, taking into grant of first ACP for which the answering respondent stated the first ACP of the petitioner was not verified by the competent authority, and the office of the Commissioner South Chota Nagpur found some irregularities anomaly in the date of regularization and promotion of the petitioner, for which recommendation for investigation has been made, and the same is under consideration as restricted in letter number 346 dated 31/10/2023, Annex 3 of the writ petition.
So you are alleging some irregularities, right? In the matter of grant of first ACP.
Yes, sir. That
Now
has
you
been
come to the
questioned.
order.
That has been questioned by the Honorable High Court, Your Lordship.
Then
Yes, sir.
you want to reopen the issues.
No,
If
no,
there was any discrepancy,
Yes.
you were supposed to bring it on record in the writ petition which has
Yes.
been disposed of.
Yes.
There was an order of recovery also.
Yes, Your Lordship. That has already been
Then?
questioned, Your Lordship.
Isn't it mischievous on your part? It
Yes.
is. Justify your action. That you can still go on for a roving inquiry after the clear order of this court.
It is not clearly stated in court, I am admitting, but actual fact is, with conversation with the department, Your Lordship, discussion with the department, we are going to pay him. He is eligible, we are not denying his claim. right from
If
first.
you are going to pay him, pay
Yes.
him with cost.
It is under process, but this is my instruction.
No,
Your
no,
Lordship.
not
We are
your-
paying
no,
him, we
no.
are not disputing his claim, Your Lordship.
You, whatever you say in your counter affidavit,
Yes, Your Lordship, I know, Your Lordship.
is,
We are
there is a total mismatch on whatever you are saying verbally,
Yes, Your Lordship.
right?
Yes, in fact, we have also.
You are trying to
said-
reopen the issue.
No. We have to comply the order of the court,
Then
and that we have to do it, Your Lordship. We have to pay, and we are not denying it.
so you pay. The matter relates only to first ACP,
Here we made a prayer.
and
for-
it is sequel to third MSCP.
Yes,
Yes.
actually we made a prayer for third MSCP because first ACP, the petitioner was even not conversant since he cannot see with his eyes. He is totally blind. Now he was not conversant as to whether the order has been complied with of first ACP.
That's
Therefore, he made a requisition under RTI. Then he came to know that a time-bound promotion given in the year 1988, that is sought to be verified now. And thereafter, when they filed the writ, they said that first ACP also requires verification. He retired in 2015. The writ order passed in 2020. They have never issued any notice, never initiated any proceeding. They have never taken any steps. And now, after filing of this writ,
By virtue of the earlier order passed in the writ petition,
yes,
you are entitled for first ACP.
yes,
Right. The recovery was set aside
Yes, yes.
by this court.
yes.
No further rider for fresh inquiry,
No,
nothing.
no, no, no.
So whatever be the date on which you get the first ACP, you will be entitled for calculation of MSCP taking that particular.
Yes, accordingly in accordance with the
Okay.
scheme.
What was the date from which you were found entitled for
First ACP was given to him. I have given the date in my list of date also with effect from 99. It was, the order was in page 3, I have mentioned it. Page 3 of the list of date. The order was of 2007 during his service tenure with effect from 9/8/99.
Should I record that you have been instructed that you are going to give him the benefit? Or should I not?
Your Lordship may record it, but I would pray it will be proper for him also that we will bring it on record that it has been granted to him.
No,
Although we have filed counter, Your Lordship, but it will be better for even
But
for
the counter is not like that. What
No,
has
but
Counter
I-
is
I-
not like that.
But I have instruction, Your Lordship.
That's
Even we
okay.
have suggested them that to make the payment because there is clear direction of the court. You
The
cannot deny
case
it.
number 6688 of 2023. Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the first ACP granted to the petitioner way back in the year 2007 with effect from 9/8/1999 was cancelled by office order dated 19/10/2012 issued under the signature of Deputy Secretary Revenue and Land Reforms Department, Government of Jharkhand, Ranchi, and an order for recovery of the amount paid pursuant thereto was also passed. The said order was subject matter of challenge in WPS number 873 of 2013, and after granting opportunity to the respondents who had filed a counter affidavit in the said case. The order regarding the order dated 19/10/2012 was
page 30, para 10.
just a minute. The order was set aside and The present petitioner, along with others, were found entitled for all death cum retirement benefits on the last scale drawn, taking into account the grant of benefit of first ACP on individual basis. The learned counsel submits that petitioner is blind.
Yes, totally. We have made a statement.
The
also.
petitioner is completely blind, and he learned that he was also entitled for third MACP, and therefore the present writ application was filed. He submits that a counter affidavit has been filed in the present case, dated 2/3/2024, taking a stand that the respondents are making certain inquiry regarding the claim of first ACP, and consequently the third ACP will depend upon, third MACP will depend upon the completion of inquiry with regard to entitlement of first ACP. The learned counsel submits that from the perusal of the stand taken by the respondents in the counter affidavit, it is apparent that they are trying to reopen the issue which was settled by order dated 29/9/2020, passed in WPS number 873 of 2013. He submits that the petitioner has attained the age of superannuation way back as on
28 to 2015.
28/2/2015, and the attitude of the respondents is apparently harassment to the petitioner.
And in rejoinder, we have stated it is contemptuous also.
Harassment and contemptuous. Harassment to the petitioner and contemptuous is in nature. The learned counsel, appearing on behalf of the respondents, does not dispute that the order dated 29/9/2020, passed in WPS number 873 of 2013, has attained finality. However, he submits that he has received instructions verbally that the respondents are ready to give the benefit to the petitioner pursuant to order dated 29/9/2020, and if the petitioner is found entitled for any further benefit under third MACP, that can also be considered. Who is the authority who will consider it?
That will be the director.
Director. Respondent number
The,
3.
the required decision has to be taken by the respondent number 3. After hearing the learned counsel for the parties and considering the materials on record, this court is of the considered view that so far as the grant of first ACP is so far as the entitlement of the petitioner for first ACP with effect from 9/8/29 in 1999 has attained finality in WPS number 873 of 2013, and the respondents are not entitled to reopen the said issue by conducting any further inquiry. So far as the grant of third MACP is concerned, the entitlement of the petitioner is certainly required to be considered by respondent number 3. Accordingly, this writ petition is disposed of, enabling the petitioner to approach respondent number 3 by filing a detailed representation along with the writ records within a period of 1 month from today. Upon filing of such representation, the respondent number 3 shall ensure that the benefit conferred upon the petitioner by virtue of first ACP is immediately remitted in the account of the petitioner within a period of uh, 2 months from the date of the representation. And so far as the entitlement of third MSCP is concerned, a reasoned order be passed after granting an opportunity of hearing to one representative of the to a representative of the petitioner
The son of the petitioner is here only.
or one authorized representative of the petitioner, which may include the son of the petitioner, within a period of 2 months from the date of communication of this order, from the date of filing representation, the reasoned order be communicated to the petitioner through speed post. If the petitioner is found entitled for any benefit arising out of third MSCP, appropriate steps be taken by respondent number 3 to ensure that the monetary benefit arising out of such reasoned order is also remitted to the to the petitioner within a period of 2 months from the date of such reasoned order. This petition is
So far as the first direction is concerned, if it is added that the consequential benefits also, because first SCP, as soon as the first SCP benefits will be given, the pay will be revised, consequently the pension will have to be refixed. So if it is, they have to do it, but if it is mentioned that it will be better.
I've just simply stated that all benefit arising out of that. If you want any such revision, etc., you mention it in your representation, item wise, and that will be taken care of.
I was saying it may be better if this
You have
output
not even
indicates.
Isn't it asking it too much?
It is the
You
it
file
is-
your representation.
it is his entitlement, therefore he is making up.
Mr. Banerjee, you don't stop at the point. That is your problem.
It is up to the output. I was saying that consequential benefits that have been proper in the interest of justice.
From dating days for
Okay.
final disposal, item 1, WPS 395 of 2023.
Yes, petitioner.
It has been filed for the compulsion passing of the NHS 6, in which the claim of the petitioner has been rejected on ground that the age
You
of
have
the-
rejected his claim of compassionate appointment only on the ground that he was overage, and that finding is only on the basis of your medical examination. What about your circulars which says that not only the medical examination but other related records are also required to be considered in the matter of age assessment? Particularly the age of the petitioner was disclosed by his father and is available in your
If
records.
the petitioner is a non-matter.
You are not getting my question.
And when he approached leadership, he was an illiterate, and as per this policy under II 76, we have recommended him to undergo an age assessment before the medical board,
Okay.
and he underwent that age assessment, wherein it was determined
You have not given him the copy of the written submissions. You have not read it,
I have read leadership.
but still you are making this submission.
Leadership only. The thing is, he is illiterate, and he had to undergo the
You are so obsessed with your thought without reading that I just don't have any words to say.
leadership.
You don't read your papers?
I
There is one judgment, you just respond to that.
yes,
Page number 45, right?
The Lilwa Pina judgment.
No, not this judgment. Judgment dated 5/9/2022, passed on WPS, passed in WPS 611 of 2018. I'm sure you know I have not read.
Leadership, I am
You have read it?
relying on the division bench judgment where it has been stated that if the age has been determined by the medical board, then that will suffice.
I just don't know whether you are assisting me or I am assisting you. I have to figure it out. You just come to page number 59.
Page para 17, which leadership has taken care of II 76.
Page number 59, running page, internal page 15, and read para number 31.
In view of the aforesaid circulars, the respondent dated such as it provides guidelines by referring the implementation instruction proposes assessment of medical board, who is also required to take into consideration various service linked documents and other documents of the ex-employee for determination of dependent age. This court is of the considered view that age of the petitioner is required to be predetermined by the medical board or age assessment committee. It is observed that the recommendation of the medical board dated such and such should not also be taken into consideration by the age assessment committee or medical board. Such examination will also include examination in various service linked documents.
Okay. One of the service linked documents placed on record is at page number
It is at page number.
yes,
29.
the family, the disclosure made by your father about your age, where is that?
Leadership one is at page 27. However, leadership, these documents have been considered by the medical board. They have written in, if leadership sees page number 28, annexure 2 series.
Okay,
They have
just a
considered what
moment.
are the
Page number
legal
27, right?
27.
Where is the consideration of service linked documents?
Leadership may see annexure 2. They have written the details what are mentioned in the service link document, and thereafter they have determined the age.
No, you just, the fresh order has been passed at annexure 6, reasoned order.
Reasoned order has been passed basing on the appeal, lordship, and leadership in this age determination. This age determination board has taken into consideration all the ages which has been determined in the declared in the service link document.
Annexure 2,
Annexure 2 series, first page itself, leadership sees page 28. Age as per service excerpt, age as per health card, age as per Aadhaar card, age as per the records, PAN card. Everything has been taken into consideration. Thereafter, determination has taken place in which he was found to be an overage. And this determination was challenged by him to the appellate board. Even the appellate board confirmed the
I'm not
decision.
getting page number 28 in my records.
About the writ petition.
They have just mixed the documents.
It was earlier written 23, then it has been cut and written 28 on top of it. It is the first page from annexure 2 series.
Page number 28. This is a pro forma for assessment of age in case of illiterate dependent for employment.
He is admittedly he is illiterate.
That's right.
Details leadership.
Let us see. But this was set aside.
This was not never set aside.
Okay.
This was challenged before the appellate board. Appellate board confirmed it.
He had come to the writ court earlier.
He had come to the writ court stating
Where
that
is that order?
yes, that order is leadership at page number 40. Leadership, he had approached this honorable court, taking seeking and direction that appellate body may decide on his appeal. It was never set aside. Allow me, it is a very short order. Allow me to place.
Yes, please.
Yes.
Please.
From paragraph 2 itself, leadership, counsel for the petitioner submits that suffice it would be that appeal preferred by the petitioner for review of his age for grant of compassionate appointment is decided by the appellate or review authority. He refers to paragraph 10 of the writ petition, submits that petitioner has approached before the director personal BCCL on such and such by filing an appeal, but no action has been taken place, and the said authority, thus the petitioner has approached this court praying that to set aside the office order as contained in such and such, dated such and such, but which the claim of compassionate appointment has been rejected wrongly by assessing age more than 35. Paragraph 10 of the taken at earliest. Thereafter, appropriate order will be passed and will be communicated to the petitioner. Considering the said submission, I direct review appellate body to dispose of the appeal, if necessary, to refer the matter to the age assessment committee, take a final decision, grievance of the petitioner. The order should be passed within a period of 6 weeks from today.
That's
If the decision of the review appellate body is so this
So
age
your
assessment-
original age assessment,
This-
let us see page number 28 for a moment. Age as per service excerpts is 18/10/1988, correct? There is no dispute on that? Okay. Health card, Aadhaar card, then other records, right? Then you have, that is all?
that is
Where is the ultimate determination of age in this order?
should I take the
Which is the determination? Where is the determination of age?
that determination, the order has not been annexed, but ladyship may see the order dated page number 38, order dated 24/9/2020, wherein we
So
have
this is not the determination of age. This is determination of, this is disclosure of the various details of the petitioner. That what all has been mentioned in which document, right? This is not a document of determination of
Ladyship,
age.
then, since it has not been annexed by the petition, we
No,
bring
no,
it
no,
on-
please no. Please don't. We will not adjourn it merely because one sentence has been said against you, right? That is your,
No, I'm only
we are not bothered about it. You should have placed it on record.
ladyship may see
No,
the
so
order-
therefore, your argument that this is page number 28 is the age assessment document is not correct.
This is, I am saying that there has been a consideration.
Where is the consideration?
We have
Show us.
considered it showing
Where is the
that there
original assessment? Where is it?
There is no assessment
Very good.
document which has been annexed, admittedly, ladyship. However, the order, ladyship sees page number 38, the order does determine that the age has been assessed to be 37 years, 6
Page
months.
number 38, right?
Yes.
The review board also mentions only the medical examination. There is no consideration of service linked records.
That
Correct? Show me consideration of service linked records in the order passed by the review board.
ladyship, the review board just confirms the findings of the medical board.
Okay.
That has been confirmed.
Now you
Ladyship,
listen
I
to
take
the
on
order.
record two judgments beside you.
Please cite your judgment. Give me those tablets.
In which it has been stated that if the age has been determined to be 37.5, the compassionate appointment has been in the 2022 SCC online.
Please
paragraph
place the facts and the paragraph.
Leadership, the paragraph in paragraph 27, the Lilwa Bhuya judgment has been taken into consideration.
Are you in a hurry?
No,
I'm not in a hurry to decide a case. When I'm
leadership,
asking you to
paragraph
place
three.
the facts of the case,
Leadership may take paragraph 3.
yes.
Dheeraj Mathur was a writ petitioner herein after referred to as the respondent made an application for compassionate appointment on 16 July 2014 before the police officer Kuju. His father Ranua Mahato was appointed on such and such and employed as pump khalasi on category 2 Kuju Kuju 29th October such and such. He had died on 22nd May 2014 while in service under Mrs. CCL. He had herein after referred at CCL. And after the death of his mother, the respondent, who was not keeping good health, nominated him for employment under clause 9.0 of the National Coal Wage Agreement, herein after referred to as NCWA. His application was processed by CCL and he was directed to by the Deputy Manager Personal Kuju area by letter date such and such to appear before the medical board Gandhinagar Hospital Ranchi for age assessment on basis of the radiology and physical examination of the respondent medical board consisting of 6 doctors. The age of the respondent was assessed between 35 to 40 years as on 20th January 2016. That is the date of his examination by the medical board. by letter dated such and such, the manager informed the staff officer PN area, Guju area, that claim of Tirat Mehta of compassionate appointment was rejected because he had crossed the age of 35 years as on 2nd September 2014. Before the report, respondent placed reliance on Aadhaar card and school transfer certificate, which recorded the date of birth of the petitioner and reference was made to the declaration by him on the affidavit dated such and such, with effect that he was born on 16 June 1986. The orders passed by the LPA in 117 of 2000 and WPS 7576 was also pressed before the report on behalf of the respondent.
That's
A stand was taken by CCL that on basis of the service sheet excerpts, the LTC and Form A as well as the such and such filled on different dates of the instances. The father of the petitioner date of petitioner was arrived at 20th July 1978. As per the company's prevalent norm, the procedure he having already crossed the maximum, the appointment on the date of the application of compartment 1 was rejected.
That's
The-
I've got the facts. Now you come, which paragraph you want to see?
Leadership may see paragraph 27 is the consideration of Lilwa Bhuiya judgment. Thereafter on 28, the Honorable Court says that it was not required for the CCL to send it for medical examination. May I please? In the first place, CCL was not required to ask the respondent to undergo a fresh age assessment by the medical board. The dependents of the deceased employees are provided opportunity of fresh assessment of their age, provided they were in possession of Aadhaar card, driver license, voter ID, ration card, school leaving certificate, etc., under which their age recorded is different from what is recorded in the service record for the employee. The procedure was applicable only in cases the service record of the employee disclosed wide variation of age where the service record is dependent.
You just can't escape like this. Please read it properly.
This
Things which
procedure-
are against you, you just can't.
This procedure was applicable only in cases where service record of the employee disclosed wide variation of the age in where the service dependence. In this present case, we do not find any such reconcilable variation in the age, and the respondents recorded in the service records of his father. In all the forms documents, the father of the respondent was almost the same. Even then, the age of the respondent was assessed by the medical board in terms of the instructions contained in letter dated 7th July 1992. The employer assessed the age to be 37.5 years. There is a wide variation more than 8 years in the date of birth of the respondent recorded in Aadhaar card, school transfer certificate compared to his age recorded in
That's-
service record of father.
So here also the service records were very much for consideration and it was required to be considered.
Right.
It does not say that once the medical board determines the age, the service records becomes irrelevant.
Leadership.
You have not pointed out that there is inconsistency so far as the service records of the ex-employee is
That
concerned.
not there, leadership.
Now you listen to the order. I've heard you.
My only submission is that they were before the medical board for consideration, which is apparent from page number 20.
That's right. WPS number 395 of 2023. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner while assailing the impugned order has submitted that the same has been passed pursuant to order passed by this court in WPS number 1758 of 2022. And the impugned order does not take into consideration the service records of the ex-employee. He has submitted that as per the service excerpts as maintained by the respondents, the age of the petitioner is, the date of birth of the petitioner is 18/10/1988. The learned counsel has further submitted that the age of the petitioner on the date of ex-employee was assessed, the date of ex-employee is 15/10/2018, and on the date of death it comes to 36 years 7 months 22 days. The Learned Counsel submits that in the medical examination, the age was assessed to be between 35 to 40 years, and the middle of the same has been taken into consideration. But the disclosures made by the ex-employee and available in the service records of the respondents has not been considered. The Learned Counsel has also submitted that there is no discrepancy or mismatch in the service records of ex-employee so far as the declaration of date of birth of the petitioner is concerned, and therefore the impugned order calls for interference. The Learned Counsel has relied upon judgments passed by this court in LPA number 687 of 2019, Lilwa Bhuiya versus CCL. Give me the paragraph.
Paragraph number 14, 15 and 16.
Para number 13, 14, 15 and 16.
16.
Other and then judgment passed in LPA number 426 of 2018 in CCL versus Vijay Kumar, para number?
Para number 12, 13 and 14.
Para 12, 13 and 14. And judgment passed in WPS number 6111 of 2018, Mahesh Munda versus CCL, para number?
Para number 9, 12, 13, 14 and 15.
9, 12,
13,
13,
14 and 15.
14 and 15. And judgment passed in WPS number 3339 of 2016, Jagdish versus CCL, para number?
7.
Para number 7. The Learned Counsel has submitted that while determining the age, the service records of the ex-employee were required to be considered. He submits that it becomes all the more important as the age was determined within the range of 35 to 40 years. The Learned Counsel, appearing on behalf of the respondents while opposing the prayer of the petitioner, has submitted that the service records of the ex-employee were duly considered, which is apparent from Annexure 2 series, page number 28. He submits that the age determination, he submits that the petitioner was communicated about his age determination and rejection of his claim for compassionate appointment by letter dated 24/9/2020, annexed at page number 38 of the writ petition. The Learned Counsel submits that the appeal filed by the petitioner, which has been decided pursuant to the order passed by this court, is a well-reasoned order, and there is no scope for any interference. The Learned Counsel has relied upon judgment passed by this court in LPA number 275 of 2017, reported in 2022 SCC Online JHAR 50, within bracket Central Coalfields Limited versus Tirath, Mehto and others, and has relied upon paragraph 27 of the said judgment to submit that the judgment passed in the case of Lilua Bhunia as relied upon by the petitioner has been duly considered. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the father of the petitioner was an ex-employee and he expired on 15/10/2018.
25/10.
25/10.
Next 15 law.
25/10 is the death certificate. On 15/10/2018, and the details regarding the various documents filed by the petitioner and as per the date of birth recorded in the service excerpts of the ex-employee has been mentioned at page 28, titled inverted comma pro forma for assessment of age in case of illiterate dependents for employment under clause 9.3.0/9.4.0/land acquisition. The said document reflects that the age as per service excerpts has been shown as 18/10/1988, and so far as other documents available with the respondents, that is form capital A, PS form 3/PS/form 4, form F are concerned, no entry has been made. However, as per health card issued by the respondents, the date of birth is again mentioned as 18/10/1988. The said document also indicates that the petitioner was recommended for age assessment by a medical board. The entries made in Annexure 2 reflects that there are certain documents of the respondents, including service excerpts and health card, which reflected the date of birth of the petitioner as 18/10/1988 as disclosed by the ex-employee. However, when the medical assessment was done, the age of the petitioner was found to be between 35 to 40 years, and by taking the midpoint, his age was determined to be 37 years and 6 months as on 23/8/2019, and consequently the petitioner was held to be not entitled for compassionate appointment in terms of clause 9.3.0 of NCWA, as he had crossed the age of 35 years. The communication to the petitioner dated 25/9/2020 has been placed on record at Annexure 3. Upon perusal of the said communication, this court finds that apart from the medical board examination, no further consideration has been made in connection with the age of the petitioner as was available in the service records of the respondents, including that of service excerpts and health card. This court also finds that the said order does not indicate any mismatch or contradiction in connection with the age, with the recording of age of the petitioner in the records of the respondents. This court finds that the petitioner had filed an appeal, and during the pendency of appeal, he had filed a writ petition being WPS number 1758 of 2022, which was disposed of by the order dated 29/2022, directing the review/appellate authority to dispose of the appeal expeditiously and within a time frame. Pursuant thereto, a impugned reasoned order dated 15/12/2022 has been passed. Upon perusal of the impugned reasoned order, this court finds that the appellate authority/review authority has also not referred to any of the documents available with the respondents regarding the date of birth recorded in the records of the respondents, including that of service excerpts or health card. This court finds that in the judgment, this court finds that in the judgment passed by this court in WPS number 6111 of 2018, it has been clearly held that not only the determination of age by medical board is required to be taken into consideration, but also the various various service linked records / documents available of the ex-employee available with the respondents are also required to be taken into consideration while determining the age. It is not the case of the respondents that before this court that service linked records are not required to be considered. This court finds that the age assessment of the petitioner as communicated to the petitioner by letter contained at page number 38, date de dijiye, as well as the order passed by the appellate authority does not reflect any consideration of service linked records / documents of the ex-employee. In view of the aforesaid facts and circumstances, the impugned order cannot be sustained in the eyes of law so far as the judgment relied upon by the respondents reported in 2022 SCC Online JHAR 50 within bracket Supra is concerned. The facts of the case indicate that for the purposes of determination of age, the appellant CCL had taken into consideration the service sheet excerpts, LTC form, etc., as well as PS form, which were a part of the service-linked documents of the ex-employee. This court also finds that in paragraph 28 of the state judgment, it has been held that CCL was not required to ask the respondent within bracket Tirath Mehto bracket of the said case to undergo fresh age assessment by the medical board. The dependents of the deceased employee were provided opportunity for fresh assessment of their age, provided they were in possession of Aadhaar card, driving license, voter ID, ration card, school leaving certificate, etc., under which their age is recorded different from what is recorded in the service records of the employee. It has been also held that such procedure was applicable only in cases where the service records of the employee disclosed wide variation in the age of dependents. And in the said case, there was no irreconcilable variation in the age of the respondent recorded in the service records of his father. It was also recorded that in all the forms/documents filled up at the instance of his father, the age of the respondent was almost the same. This court finds that the judgment which has been relied upon by the respondents, if read in totality, is actually in favor of the petitioner. However, the various service records of the ex-employee in the present case is required to be considered, and if there are any further declaration of the father of the petitioner regarding the age of the petitioner is also required to be verified, and a fresh determination of age of the petitioner is required to be undertaken, taking into consideration the service-linked documents of the ex-employee. Accordingly, the impugned order cannot be sustained in the eyes of law. The matter is who will do it?
Okay, but will be delegated to the GM of the respondent number.
West Bengal. To the respondent number 3.
Yes, the respondent.
Let fresh decision be taken by respondent number 3 upon filing a representation by the petitioner. Detailed representation, you file whatever you have to, along with the writ records. The respondent number 3 shall seek necessary information from the other respondents with regard to the petitioner slash service linked records of the ex-employee, and grant an opportunity of hearing to the petitioner, and pass a reasoned order within a period of 2 months. 2 months from the date of receipt of a copy of this, from the date of filing of the representation. The reasoned order be communicated to the petitioner through speed post, and if the petitioner is found entitled for compassionate appointment, the needful be done by the respondent number 3, so that the needful be done by respondent number 3, so that the reasoned order is also complied within a period of 2 months from the date of the reasoned order.
My ladyship, set aside the impugned order.
I have set aside.
Both of the page number 38.
Both
38.
Both the impugned orders are set aside. Mr. Das, service linked records are required to be seen.
Yes, yes.
So that has not been done. And in revision bench which you have cited, it has gone to the extent
It's
that
not-
if there is no discrepancy in service records, there is no requirement of
That is our, that was in fact, but so I could not come in.
No problem.
I was under the impression to taken up as a first case, but I was not, I did not see this supplementary list. Only when where favorable orders are passed, when his name can come, but.
Let the GM pass the order such that the entire area knows about
Entire
it.
record, yes.
Item 3, WPS 6693 of 2023.
You give your appearance memo, please.
Not it appears an enormous counter affidavit has been filed with your lordship's permission yesterday. But not as I have been taught all throughout my career as a lawyer, even an innocuous counter affidavit has to be cornered specifically in rejoinder, less, Lord, some may say that readings have not been traversed. Therefore, Lord, sir, kindly grant me time. This is the same matter, Lord, status. So kindly grant me time till 21st.
I don't think that by filing an affidavit it can be done. You have to file an interlocutory application to challenge it. Because that order is required to be set aside.
Which
This is
order?
what I feel.
Because this is annexure A, I have gone through it, is a decision taken by 3.
By
which
saying
is-
that it is equivalent. By stating that it is equivalent. It would be better if you specifically challenge it. Otherwise, there will be a problem in granting you relief.
My Lord, I understand, my Lord. I don't want to waste your Lordship's time. I have been watching very.
I was waiting for a call yesterday that you will be seeking time or
Your
not.
Lordship has said after the counter affidavit is filed, I could inform the court master.
But no such information had come, and I had spent around 1 hour to go through the entire records,
My Lord,
assuming
I'm
that
so-
you will be
my
arguing
Lord,
the case
I'm so
today.
sorry, my learned friend
Your
points
learned
out.
friend has been irresponsible
No, she points out that
So-
she was served with a copy of the counter only in the second half.
She knows that I am awake till 2 o'clock at least. She could have informed my court master. She knows it very well.
Miroz, I apologize on her behalf. Miroz, in fact, I was supposed
I
to.
was reading it and
Miroz,
trying to figure out as to whether you can
Manoj.
still continue with the argument. I thought that you need to file a.
only one query. I can't ask question from a court, Miroz, and much less a hard-working court like yours. Miroz, have your Lordship gone through my submissions? Yeah.
I have gone through. We will see it. You
Manoj.
file your required affidavit, right?
Miroz, as your Lordship directed, by 22nd I will file it.
Okay.
Will your Lordship post it on 1st? Only with a view, Miroz. He is supposed to superannuate. And we are faced with a paradoxical question. Engineer-in-chief and stroke chief engineer. And chief engineer is the feeder post with duties distinct. I mean, take it, but I don't want to speak out of the Miroz
That's
without
right. Kindly do that because if you file your reply by 22nd, your affidavit by 22nd, they also need some time. In the meantime, there is
Then Miroz,
holiday.
4th of April, Miroz, I am supposed
Will you be
to.
able to respond if they file their affidavit by 22nd?
Miroz, rejoinder, I have to come out with no new facts.
You want to only rejoin it?
I'll prefer Miroz, file both, and
Take care, whatever. Yes.
Miroz 4th.
There will be holidays.
Your department is also on a holiday. Time is running against them. If they are in,
You'll also fixing 4th.
yes, I'll fix it on 4th. And if you want to respond to that, you file it by 3rd at least. I'm giving you 2 additional days time after reopening, so that you can go through it and don't file an affidavit merely on instructions. You be satisfied with it, right? Okay. You take care of the rules 2016.
Yes.
I think 2016 rules govern you. WPS number 6693 of 2023. An affidavit has been filed pursuant to the order passed by this court. Learned counsel for the petitioner seeks adjournment to take necessary steps in connection with the affidavit.
Absolutely. Miroz,
The
your
needful
Lordship.
be done by 20. Will it be possible by 21st? 22nd
Miroz,
is last
I'll
working
try
day.
to.
Our office is
Miroz,
absolutely
in
in a
fact,
mess.
had I come yesterday, I was supposed to appear in a matter at 10:30. Miroz, the court for some reasons had only at 10:40. I missed my flight. My commitment to this court was so great that at this age, I took a car, drove all the way from Patna to Ranchi so that I'm not a defaulter.
It's a pleasure to hear you always.
Miroz,
They've heard you so many days. Your advocacy is par excellent. You don't have any doubts on that. And you don't need a certificate from me.
Miroz, any time, my lord. Every
You don't need
time,
a
my lord,
certificate
I will
from me.
need it.
It's everybody knows about that. So can you do the needful by
My lord,
21st?
I will try to, my lord.
Okay. The affidavits, if any, be filed by 21st of March. Post this
Could
case.
your lordships use that word preferably by 21st?
Okay, preferably by 21st of March. If the affidavits are filed by 21st of March, the response, if any, be filed by the respondents by 3rd of April.
That will do, my lord. The question of law, my lord,
Yes.
basically,
Post on 4th of April.
for final disposal.
It is already there for final disposal, I suppose. You know, I'm a very slow court. I take my own time to read.
Lord, sir, my lords are entitled to my lord's views. We are entitled to our views with regard to my lord's views. And I don't agree with
At
that.
times, I'm told that don't read brief so much. But one thing I must tell you, even if I read the brief, my mind is open till the end.
Lords, that
I
is-
do not stop anybody from canvassing the
Lords,
arguments.
I say, my lords, with respect and humility, that is how it should be. As my lords, there was a great consul, criminal lawyer from Patna, Nageshwar Prasad, from the criminal.
Very famous.
Lords, he used to say, please read the FIR a couple of times. The first time you read it, some light will come. You read it, a different light will come. Therefore, my lords, a man may see a particular fact in a particular prescription with a particular mind. The others may point out that there is some other light to it. And that is why what your lordship does.
In some
is
paragraphs, I'm stuck for 1 hour also. I am really disclosing it to you. In some paragraphs, I am stuck for 1 hour also.
Because if your lordships are going to Justice
comprehend.
Krishna Iyer's judgment, then if your lordships really dealt with few paragraphs, it would take days, my lords.
I know. Great he was.
My lord, if any compilation is filed by on behalf
You have not got the copy?
No.
My lords, the citation are all reported.
No, please provide them a copy.
One
You
copy,
see,
my lord, just have.
We have a poor state.
All right, my lords. In fact,
Kindly provide them with all proper page numbering during the course of the day. You provide it to them, please. There is one
Those are
spiral,
all
one more bundle was there. List of
that
dates.
is, and there is another submission that both of them were given. They were citation of reported case law, therefore.
Citation was given earlier.
Kindly provide it to them. It will be easy at the time of hearing.
And
But
I will advise
Mr.
my learned
Bhaduri, ensure reading it also.
friend, no, especially
And if
the
any judgment is cited by them, that
judgment of what they-
No, whatever you are citing, provide them copy.
ये judgment नहीं है.
If I cite anything, I'll first provide.
it is
All right, let's see.
अलग से है. This is the
I will suggest them, my lord,
list of dates and
he
the
should
then
read this judgment for what they say, the judgment number 7 properly.
Let's see. Mark that judgment number 7.
I've read it as well.
You have read it?
Yes, my lord, if it is.
I can never have the audacity to say that I have read it fully.
Fully, my lord, I've read it.
Take
Just
care.
I was examining.
When you read the judgment, you keep in mind the thought process of the petitioner. Then read it. Then you will understand it better. And you will be in a better position to counter it.
Yes.
For orders to effect, item 4, criminal division 1589 of 2019.
In this case, Lordship, there are several defects, and one defect is for condonation of delay. Lordship. I have filed an IE for condoning the delay for 11 days. And so far,
Surrender certificate.
yes, Lordship, surrender any date may be given, and he will surrender before the procedure. Lordship. And rest about the, I will remove in course of the day.
You have taken the court for a ride. Way back on 10/11/2020,
Yes.
an order was passed
Yes,
to remove the defects, and you are given an undertaking to remove the defects.
in course of the day I will remove Your Lordship.
No, I just want to know why have you not done it?
Because surrender certificate नहीं आया था जिसकी
नहीं आया था मतलब क्या? सरेंडर करने से सरेंडर सर्टिफिकेट आता है या
Yeah.
बिना किए आ जाता है?
No, therefore I am praying.
Therefore what?
Any date may be given, he will surrender.
There are concurrent findings against you. A convicted person is let loose against law, isn't it? Then
Only last chance may be given.
notice has been issued? Not yet, because it is still a defective petition.
Yes, Your Lordship.
How much is the amount involved?
$2,80,000, Your Lordship.
You want to remove the defect in how many days?
Rest of the defects remove. I will.
We are not concerned with rest. I'll pass a peremptory order. You just tell me how
Yes.
much time do you need,
2 weeks.
including surrender certificate.
Yes, Your Lordship.
Criminal revision number 1589 of 2019. Counsel for the petitioner prays for and is granted time till 4th of April 2024 to remove the surviving defects peremptory. If the defects are removed within the stipulated time, pose this case on 10th April. Wednesday को रख दे रहे हैं,
Yes.
right? Such that कम से कम custody आपका हो. चलिए.
Item 5, Criminal Division 37 of 2020.
Also, in this case, I may be permitted to withdraw this.
Criminal Division number 37 of 2020. Learned counsel for the parties are present. The counsel for the petitioner seeks permission to withdraw this writ petition. Accordingly, this petition is dismissed as withdrawn.
Sign.
So, there is an interim order.
Notices were sent to the OP number 2. In the meanwhile, petitioner got surrendered Lordship and completed his conviction.
देखिए प्रेयर को प्रेयर में ना मुकुल जी आपके प्रेयर में जितने रिवीजन होते हैं ना उसमें एक इम्प्यून्ड ऑर्डर जरूर है, ठीक है? तो उस इम्प्यून्ड ऑर्डर का डेट एंड डिटेल लिखना चाहिए और किस कोर्ट से पास आइए क्लोज.
Item 6, Criminal Division 449 of 2020.
On the last occasion, Honorable Court has given direction to the learned court below to take all coercive steps to arrest these petitioners. And they have gone to surrender there, but Your Lordship, there is no record at all available that they have not, therefore they have not taken surrender of that petitioner.
No record available.
No record of this case is available with the learned court below, Your Lordships.
And
That's
therefore,
why-
in spite of petitioner wanting to surrender, he has not been taken into. Should I record it? Which court is that?
As per their instruction,
We do not know. You see, it's a
Making
very
some-
serious statement. A person is going to surrender, and he is not taken into custody because the records are not there.
This is, yes, Your Lordship, this instruction has been given by petitioners, Your Lordship, by the learned court, counsel of the learned court, Your Lordship. He has conveyed this submission, Your Lordship. This is the, Your Lordship, this is the truth, Your Lordship.
You put it on affidavit. एक और criminal case हम लोग institute करेंगे. You put it on affidavit. You have the PADV card. Somebody must have instructed you.
Yes, Your Worship.
Advocate is nobody. He will file an affidavit that this has happened. Will he file his personal affidavit?
तो फिर Your Worship एक दिन का टाइम I will take instruction क्योंकि यही वो बताएं Your Worship जो हम सबमिशन कर रहे हैं. यही इंस्ट्रक्शन मेरे को मिला है Your Worship.
Madam, this is going to be very, very serious. Not if it is found to be correct, then it is going to be very serious on the court concerned, and we'll book somebody for that. We will take it on affidavit. We will not take your oral submissions like this.
This case may be taken up tomorrow, Your Worship. After taking instruction, I will make submissions.
Which is that court? Where did you surrender? Which court did you surrender?
The name of the concerned court, Your Worship. I will convey it tomorrow, Your Worship. बस एक दिन का टाइम दिया जाए हम instruction.
बहुत responsibility से statement बोलिएगा.
Yes, Your
And
Worship.
take the statement on WhatsApp at least.
Okay, Your Worship.
Because we need to protect you. We do not know under whose instructions you are making these submissions.
Yes, Your Worship.
And keep that WhatsApp chat or email communication safe and ready to be used at any point of time. At the request of the counsel for the petitioner, post this case tomorrow. With all details.
Yes, Your Worship.
Where did he go? When did he go? For surrender certificate, he must have prepared an affidavit.
Yes, Your Worship.
Where is that affidavit? You take that affidavit also with you.
In the year 2022, he went to surrender, Your Worship.
That's right. So therefore, that affidavit must be there, no? Yes.
Item 7, Criminal Division 682 of 2020.
Surrender certificate has been filed. Criminal Revision number 682 of 2020. In spite of order dated 9/9/2021, the defects have not been removed. Accordingly, this criminal revision application is dismissed. Prayer कोट कर दीजिएगा पूरा. Let this order be communicated to the concerned court along with order dated 9/9/2021. If the petitioner has not been taken into custody so far, यहाँ पे रिपोर्ट भी करने के लिए था, क्या हुआ? रिपोर्ट नहीं आई. There was a direction to take all coercive steps for apprehension of the petitioner and to commit him to jail custody for serving out rest of the sentence. The report has not come. The report in terms of order dated 9/9/2021 be forwarded to this court कौन रिपोर्ट बनाएगा? रजिस्ट्रार सरेंडर करके वो किया कि असिस्टेंट रजिस्ट्रार कौन करेंगे? वहाँ के रजिस्ट्रार होंगे ना कोर्ट के. By the learned registrar of the concerned court. The report is directed to be submitted by 30th of April 2024. The report be placed on record by the registry. This petition is dismissed. जैसे ही रिपोर्ट आया आपको दिखा दीजिए. ठीक है? Petitioner absent लिख दीजिएगा. Nobody appears for the petitioner. आप अपने appearance record.
For orders item 8, Resolution 585 of 2019 along with item 9.
Petitioner. Why is it listed for orders? Yes.
जो लास्ट टाइम वो ये हुआ था जॉइंट कॉम्प्रोमाइज लोग पहुंच के रिवील किया था
जॉइंट कंप्रोमाइज डिस्पोजल भी हो गया है जो 22/10/2022 का होगा 19/10/2022
तो फिर ये चल क्यों?
और फिजिकल अपीयरेंस भी किया प्रोविजनल बेल पर चल रहा है मैडम.
प्रोविजनल बेल तो एक्सटेंड नहीं हुआ.
31/3 तक है मैडम.
31/3/2024. कौन सा ऑर्डर से?
लास्ट ऑर्डर 29/9 29 नॉट 2023
31/3/20. जॉइंट कॉम्प्रोमाइज फाइल हो गया?
यस.
कौन सा में हुआ है बताइए.
आई नंबर
19/10/2020 को क्या हो गया जॉइंट कॉम्प्रोमाइज में?
उसमें फिजिकल अपीयरेंस भी था ओपी नंबर 2 का. अपेयर भी की थी और ये साथ में रहने के लिए इन लोग गए भी थे और रह भी रहे हैं.
साथ में रह रहे हैं.
ये नंबर 18596 8596 पारा 8 है जो देखा जाए टुडे दो ओपी नंबर 2.
Where is the joint compromise petition compounding the offence? Where is it? This is under 498A only.
498.
Where is that joint compromise petition?
I number 859.
RA number?
8596. Of 2020.
Have you received any instruction from the informant, the wife?
लास्ट 2 months से इंस्ट्रक्शन नहीं है मेरे बट रेगुलर इंस्ट्रक्शन है. साथ में रहे थे बच्चे भी हुआ है इनको.
तो ये ऑर्डर्स में क्यों आ गया? प्रोविजनल बेल इज ओनली टिल 31st. कन्विक्शन कौन सा सेक्शन है?
498A and
323.
498A and
4 of
कस्टडी कितना हुआ?
Then
2 years का conviction है।
2 years.
कस्टडी कितना हुआ है पूछ रहे हैं तो कन्विक्शन बता रहे
28/1/2022 से कस्टडी में थे.
कब से? कब से?
कस्टडी सिंस 28 जनवरी 2022.
तब से कब तक?
More than 5 months already कस्टडी में थे.
बताइए ना डेट.
Surrender certificate फाइल किया।
ना सर. बाद में ज्वाइन करा.
प्रोविजनल बेल हुआ है आपको बिना सरेंडर सर्टिफिकेट फाइल किए?
नहीं, हम लोग आपस में फिर
हम आपसे जानना चाहते हैं
इसमें हुआ था जो
प्रोविजनल एंटिसिपेटरी बेल हो गया है?
नहीं, प्रोविजनल बेल के जेल में थे और हम लोग उनके वाइफ और उनका
Compromise के basis पर
कंप्रोमाइज बेसिस पर उनको प्रोविजनल बेल मिला था.
तो कस्टडी का में कब गए?
तो 16/9/22 से प्रोविजनल.
आप कस्टडी का डेट बताइए पहले. 16/9/22 से तो प्रोविजनल बेल हम सुन रहे हैं, आप हमको कस्टडी का डेट बताइए. रिलीज तो तब ना होगा जब आदमी जेल जाएगा, कि बिना जेल जाए रिलीज हो जाएगा.
जेल में थे.
हाँ बताइए, डेट बताइए.
हम 28/1/2022 से जेल में थे. हम
बत-
सरेंडर किए थे.
बताइए ना कब. वो सरेंडर सर्टिफिकेट तो होना चाहिए ना यहाँ पर.
ना बाद में हम लोग कंप्रोमाइज किए. बाद में हम लोग कंप्रोमाइज.
आप हमको 18/1
28/1/2022 से अब तक कस्टडी में गए.
2019 से ये केस चल रहा है.
जी.
तो ये जो कस्टडी में आपके 28/1/22 से
एक और एक केस था और इनके साथ और एक तो केस था. इसी भी हम लोग गए.
कहाँ है? फ्रॉम वेयर डू आई गेट योर कस्टडी फ्रॉम दिस? देयर इज अ मिनिमम सेंटेंस अंडर द एक्ट. आर यू अवेयर ऑफ दैट? आपके कॉम्प्रोमाइज से मिनिमम सेंटेंस ऐसे सेट असाइड नहीं हो जाता है. I have to pass a reasoned order for setting aside the minimum sentence also. Dowry Provision Act. Which shall not be less than 6 months. And for adequate reasons, we can relax it.
Yes.
So I must know your custody.
टू केस में हम पास कर रहे हैं.
Where is your IA for provisional bail? Where is your IA for provisional bail? Page number 8 is blank. पहले तो हम पता करते हैं आप सरेंडर किए भी थे कि नहीं किए. I do not know. You just see your IA. LCR में होगा. 2019 में LCR आ गया. You see, just see your petition, para number 8 of your provisional bail application, right? Who has surrendered before the learned court below. The petitioner has surrendered before the court below on dash, unfilled. इतने इनोसेंट मत बनिए. इतने इनोसेंट एडवोकेट होते नहीं हैं, राइट? कुछ ऑर्डर नहीं करेंगे आप, सरेंडर करना पड़ेगा, उसके बाद ही ऑर्डर कॉम्प्रोमाइज
मगर 2 days में पास
पास ओवर करिए, रिकॉर्ड चेक कर लीजिए। State, see from the records, he was granted you are there in this case? कब सरेंडर किए हैं ये? दिखाइए रिकॉर्ड से। सरेंडर सर्टिफिकेट फाइल्ड नहीं है। प्रोविजनल बेल में द डेट ऑफ सरेंडर इज ब्लैंक। हाँ, सो हु विल टेक केयर ऑफ दिस? कॉल करिए नेक्स्ट केस। कॉल करिए, पास हो।
Passover case from supplementary list, item 2, WPH 800 of 2022.
In this case, Your Lordship, we have not been able to compile all the judgments. So I was only praying it may be placed on Monday or Tuesday.
WPL number 800 of 2022. The learned counsel for the petitioner has submitted that though the matter was heard at length yesterday and today the petitioner was today he was supposed to place the judgments being relied upon, but he has not been able to compile the judgments. Pose this case on on the request of the counsel for the petitioner, pose this case on 18th of March 2024. Will you be able to place the judgments by tomorrow, or you need more time?
Only more time, Saturday, Sunday we will get you.
I appreciate it. Then pose this case on 1st of April 2024. The compilation of the judgments should be filed by 18th of March. Let this matter be treated as started.
From daily list item 10, Criminal Division 1323 of 2019.
ये फाइनल डिस्पोजल में है ये वाला मैटर। लिखिएगा टू बी टेकन अप एट 2:15, ठीक है, कर दीजिए और उनको खबर कर देंगे। आप मिस्टर तिवारी को खबर कर देंगे 1 अप्रैल को 2:15 के लिए रखें। पाठक मैटर को हम ऐसे नीचे नहीं जाने दे सकते।
Item 10.
Yes, petitioner.
Yes, 138 मैटर, इसमें कंडीशन में 3 मंथ का और 3,60,000 देने का IN नंबर।
आप सरेंडर नहीं किए हैं?
नहीं, सरेंडर ज्वाइंट कंप्रोमाइज।
सरेंडर नहीं किए हैं? ज्वाइंट कॉम्प्रोमाइज हो गया आप लोग का?
जी, ज्वाइंट कॉम्प्रोमाइज हो गया है और उसके एक अलग से कॉम्प्रोमाइज भी बना है लॉर्ड्स। उसमें 3,60,000 रुपए चेक के माध्यम से प्राप्त भी कर लिए 12,600 तक।
There is a direction to take you into custody by order dated 23rd of February 2020. आप सरेंडर करके
एक आइए और एग्जामिनेशन के
कहाँ फाइल की?
सेकंड आई
पहले आइए रिजेक्ट हो गया था। पहले कोई आईए रिजेक्ट हुआ था, आईए नंबर बताइए।
IA number 2548.
आप लोग कॉम्प्रोमाइज कितना अमाउंट में किए हैं?
3,60,000 हमको रिटर्न कर दिए।
रिटर्न करेंगे?
कर दिए।
कर दिए, हो गया, पैसा भी आ गया।
हाँ, रिसीव भी हो गया। ज्वाइंट कंप्रोमाइज अलग से सेपरेट एक कंप्रोमाइज पिटीशन फाइल हुआ है।
कहाँ है बताइए?
आइए के साथ
IA का नंबर जो है 2516 में, दोनों में हम पाए हुए हैं एग्रीमेंट जो है आप समझौता, पेज नंबर 12 में
2516
साल 2024।
ये जरा क्लैरिफिकेशन। पढ़िए जरा अपना कॉम्प्रोमाइज पिटीशन।
यस, जो एनेक्सर लगाएंगे उसको
नहीं, पिटीशन पढ़िए, पैरा नंबर 4 से 5 से पढ़िए।
The present joint petition has been made by interlocutory of being been filed by way of that the friend the petitioner and complainant has been settled the dispute and meeting but out of the court. Both party has been entered into compromise agreement dated 28 से 2018 has been entered into between them. The petitioner has been paid check amount to the complainant for the which the complainant accepted the now the OP number 2 has no grievance against the petitioner and OP number 2 does not want to proceed when this case further more than an OP number 2 has no intention in that case the litigation between the OP number 2 and the petitioner all given by fulfilled.
ठीक है, क्रिमिनल रिविजन नंबर 1323 of 2019। The learned counsel for the petitioner and counsel for the opposite party number 2 are present. The learned counsel for the petitioner, the learned counsel for the parties have submitted that, jointly submitted that, prayer लिखिएगा that IA number 2516 of 2024 has been filed by way of joint compromise petition and it has been stated therein that parties have settled their dispute by entering into compromise out of court. A prayer has been made that this revision be disposed of in terms of the compromise the learned counsel for the respondents opposite party number 2 has submitted that he has no objection if the conviction of the petitioner is set aside as the opposite party number 2 has received the check amount, and opposite party number 2 does not want to proceed any further in this case. यही है आपका कहानी?
जी.
State any objection? The learned counsel for the state has no objection. The prayer for joint compromise. After hearing the learned counsel for the parties and considering the fact that petitioner and opposite party number 2 have filed a joint compromise petition being through IA number 2516 of 2024, and it appears that they have settled their dispute this criminal revision number 1323 of 2019 is disposed of in terms of joint compromise between the parties, and consequently the impugned orders passed by both the learned court are also set aside. So far as IA number 2548 of 2024 is concerned, the same has been filed seeking an exemption from surrender. In view of the aforesaid order, the said interlocutory application has become infructuous. This petition is accordingly disposed of communicated.
Order communicated.
Of course it will come.
How much of it?
Let this order be communicated.
Item 11, Criminal Division 9 of 2019.
This is the case of 38 and IF.
Sorry?
Compromise has been done in this case. And
There is a joint compromise.
Can you have time for filing the documents regarding that? आ गया है, इसको हम फाइल कर देंगे after some time. After होली रख दिया जाए इसको हम लोग फाइल करवा देंगे. अपोजिट पार्टी भी अपियर हुए हैं.
ओल्ड एज की वजह से नहीं आ पाएगा.
लोअर कोर्ट पे एग्रीमेंट बना.
एग्रीमेंट बन गया?
हाँ बन गया है, इसको हम लोग फाइल कर देंगे और आइए भी फाइल कर दे रहे हैं इसका.
तो अगला वीक रख देते हैं ना, फाइल कर दीजिए.
वो बुजुर्ग आदमी है, बता रहे हैं थोड़ा सा उनका तबीयत भी ठीक नहीं है तो आ जाएंगे. 78 ईयर ओल्ड है.
कहाँ के रहने वाले हैं जो नहीं आ?
कोडरमा के दोनों पार्टी.
कितना में सेटल किए हैं?
फुल अमाउंट पेमेंट हो गया. देखिए
Learned counsel for the parties are present. Counsel for the parties have submitted that parties have entered into compromise outside the court. Check amount payment किए कि compensation amount payment?
फुल अमाउंट जो 2,20,000 देने का है वो पूरा अमाउंट पेमेंट.
As per the impugned order, 2,20,000 compensation.
2 लाख मजिस्ट्रेट कोर्ट से हुआ था, अपीलेट कोर्ट से 2,20,000 हुआ.
The learned counsel for the parties pray for time to file a joint compromise petition. Pose this case on 4th of April 2024 under the heading for orders. The joint compromise petition.
After Holi next week रख दीजिए.
After Holi next week ही रखें.
8 तारीख वाला 8-9 या.
आपका होली 4 तारीख तक चल रहा है क्या?
नहीं. अच्छा बुला लीजिए. बुजुर्ग आदमी इसीलिए बोल रहे हैं.
बुजुर्ग आदमी है इसलिए जल्दी बुला लीजिए. नहीं तो जॉइंट कॉम्प्रोमाइज पिटीशन नहीं भी फाइल होता है। बुजुर्ग आदमी को विशेष ध्यान रख के बुला लीजिए, ठीक है। द जॉइंट कॉम्प्रोमाइज पिटीशन बी फाइल बाई 3rd of April.
Item 12, Criminal Division 17 of 2019.
So offences notes are alleged notes under section 198A of the 34 of the IPC notes and 3 of the 4 of the notes. So this case notes that prayer for discharge notes has been rejected notes against which notes the present division notes have been filed. Notes 2 petitions are there notes.
What is the stage of the case?
One more fact notes I need to say. Petitioner number 1 notes are that she is mother-in-law.
So
Notes,
so you will not press so far as mother-in-law is concerned.
mother-in-law is concerned.
What is the stage of the
Stage
case?
notes, current stage notes, I have tried to contact notes, applying notes 2-3 days back notes. Notes into filing of notes on 2019 notes.
So it must have proceeded. फैग एंड में होगा ट्रायल।
एक बार वो जो उसका स्टेटस
नहीं, उसका क्या स्टेटस आपको खुद ही देख के रखना चाहिए ना स्टेटस।
करने की कोशिश कर रहे थे।
नहीं होगा आपसे कांटेक्ट
2019
क्योंकि अब उसको कोई इंटरेस्ट नहीं है।
नहीं है बीच में वो को कांटेक्ट
भाई डिस्चार्ज में अब क्या इंटरेस्ट होगा जब प्रोसीड कर गया होगा ट्रायल तो। नहीं, you argue your case, you want order on merit, I will give you an order on merit. विड्रॉ नहीं करिएगा बाद में।
जी।
चलिए।
Notes previously notes Sierra criminal division notes 151917 notes was filed notes for dishonorable court notes. The coordinate notes bench of dishonorable court notes were pleased to set aside notes the order of discharge of the learned court below notes and thereafter notes have directed notes to file a place order notes. Then notes the present order has been passed. Notes so far has been notes petitioner number 2.
Where is the earlier order?
Earlier order notes have not passed. हम लगा देते हैं उसमें।
आप स्टेटस पता कर लीजिए, आप उससे नहीं पता चलेगा क्या? आपको नहीं पता चलेगा क्या? हाँ तो पता करिए, इसको कल रखते हैं, आप ऑर्डर फाइल करिए। पुराना ऑर्डर कहाँ है आप? कल रख
13/6/2000 I am appearing for the informant।
हाँ
13/6/2023 को चार्ज के लिए था, उसके बाद से चला आ रहा है चार्ज पे ही। एक अभी लास्ट डेट 16/3/24 को ही है नेक्स्ट डेट
चार्ज के लिए। तो इतना दिन से चार्ज क्यों नहीं फ्रेम? नॉन कोऑपरेटिव चल पता चल गया क्या स्टेज। बट 2013 का केस में आप यहाँ पे फाइल करके सो रहे हैं। 82, 83 सब हो गया है, क्या चल रहा है? हो ही गया होगा तभी उसके बाद पकड़ाए होंगे, कुछ हुआ होगा।
ये जो लेडी थी, ये लोग दोनों ओल्ड एज लेडी, ये एजिंग लेडी है, बेडरिडन थी। डेथ के पहले वो जो पिटीशन नंबर 1 शी वाज बेडरिडन।
कब? इंसिडेंट के पहले?
उनके डेथ के पहले। डेथ हुआ है 16/10/23 को।
अच्छा।
उस वक्त
इंसिडेंट के समय तो ठीक ठाक थी ना?
इंसिडेंट के समय so far not the allegation in the FIR is concerned।
Yes, kindly please.
None of the notes incident has taken place notes in Ranchi. That big notes I have also taken in my petition notes. The entire notes incident notes has taken in Patna.
So there is no jurisdiction.
Yes, ma'am. The jurisdiction plea notes I have also taken notes in my petition notes.
Where is your FIR कौन फाइल किया है?
FIR notes
The lady.
lady.
Okay. What else?
So far notes the petition number 2 is concerned notes. उनके against notes भी मुझे कोई allegation as such FIR नहीं है।
Petitioner number 2 is the husband?
No, no. She is the bossy sus, aunt notes of the husband. Bossy sus. She is the distant relative notes still.
What happened to the husband?
Husband notes is on bail.
Husband is on bail. Husband का भी discharge फाइल किया?
नहीं, husband नहीं।
That's all?
So कल
क्या हम सुन लिया अब क्या कल? क्या जजमेंट प्लेस करना? आज आप आए हैं, आप बस हो गया।
हम ज़्यादा टाइम से कल
नहीं, बहस करने के बाद हम adjourn नहीं करते हैं।
एक फैक्ट
नहीं,
को और इंक्वायर करना
कुछ नहीं, कुछ नहीं।
नोट्स खाली नोट्स
Nothing.
नोट्स इसमें जो नोट्स दी मैट्रिमोनियल सूट नोट्स जो फाइल हुए हैं नोट्स दैट ग्राउंड नोट्स आई हैव टेकन इन द पिटीशन नोट्स दैट द प्रेजेंट केस इज नोट्स ऑफ द काउंटर ब्लास्ट ऑफ द मैट्रिमोनियल सूट नोट्स इसमें सिर्फ हमको वो डेट नोट्स इंक्वायर करना है कि नोटिस सर्व होने के बाद नोट्स द प्रेजेंट केस नोट्स हैव बीन लॉस्ट दैट डेट नोट्स ओनली हैव टू इंक्वायर नोट्स did that extent notes I am
कोई
taking
बात
नहीं।
The criminal revision number 17 of 2019. The counsel for the petitioners and opposite party number 2 are present. This case was filed way back as on 5/1/2019 and it has been informed by the learned counsel appearing on behalf of opposite party number 2 informant that the matter is still pending for framing of charge. And the next date is 16/3/2024. The counsel for the petitioner has submitted that so far as petitioner number 1 is concerned, she has already expired, but no document in support of the same has been filed by the petitioner before this court. Counsel for the petitioner, while assailing the impugned order refusing to discharge, has submitted that the petitioner number 2 is distant, is Mausi Sas, is cousin mother-in-law, right? Is cousin mother-in-law, within bracket Mausi Sas, of the opposite party number 2. And in the first information report, there is no specific allegation against the petitioner number 2. He has also submitted that all the incidents had taken place at Patna and the case has been registered in Ranchi. The learned counsel has further submitted that the case was registered as a counterblast of the divorce petition filed by the petitioner.
Matrimonial division suit number 43 of 2013. Notes in para 18 notes.
Matrimonial
division suit number 43 of 2013.
Para number
18 notes. Page 11.
Not pursuing divorce.
Just a moment. Being matrimonial within bracket division bracket close suit number 43 of 2013 before the court of learned principal judge family court Patna. The learned counsel appearing on behalf of the opposite party number 2 has opposed the prayer of the petitioner and has submitted that the impugned order refusing to discharge has been rightly passed. The learned counsel submits that the FIR by itself is not encyclopedia of all the materials, and the impugned order has been passed after considering the materials collected during investigation. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the impugned order passed by the learned court below, which is dated 3/10/2018, is a well-reasoned order taking into consideration the materials collected during investigation and also the allegations made in the FIR. The learned court below, after scrutinizing the material, has recorded that there are sufficient materials on record to indicate a prima facie case and has rejected the revision application and has rejected the application. The petitioner has not even filed a copy of the petition for discharge filed before the learned court below, along with the present petition, and from the perusal of the impugned order, it appears that the submissions which were made was that there was no evidence available on record to prove the involvement of the petitioners in the alleged allegation of cruelty to the informant and demanding dowry, and finally ousted from the matrimonial home. It was also argued before the learned court that both the petitioners are very old ladies and suffering from old days complications, and that the allegation made by the informant in a written report is totally fabricated and the petitioners have been falsely implicated in the case. After going through the impugned order, this court finds no illegality or perversity calling for any interference in revisional jurisdiction, and accordingly the present revision is hereby dismissed. Committed.
No, I don't know. I don't know.
आपको जब मन होगा तब आप आके इंटरवीन करेंगे. You wait for some time.
Item 30.
So what will be taken up at 1 o'clock, not prior to that.
Item 30, Criminal Division 33 of 2019.
Petitioner. Where is the petitioner? Criminal Division number 33 of 2019. Nobody appears on behalf of the petitioner. By the order dated 6/8/2019, the status of the case was called for and has been communicated to this court by letter dated 26/8/2019. Upon perusal of which, it appears that 2 witnesses were examined and 6 were remaining to be examined from the side of the prosecution, as on 26/8/2019, and the next date was fixed on 3/9/2019. It appears that the trial has progressed, and since the petitioner is not appearing, this petition is dismissed for non-prosecution.
Item 14, Criminal Division 36 of 2019.
Yeah, please, Your Ladyship. This order under challenges against the order of conviction, Your Ladyship. The applicant has been granted bail by order in the year 2020, Your Ladyship. Your Ladyship, since the matter was listed, I've been trying to contact the client, Your Ladyship. It's an old matter.
You have got the records?
Yeah,
You argue?
No, Ladyship.
You don't need the client to argue the case.
If at all the client is there or not also.
No, we
Your
don't
Ladyship.
need to. We will not assume that the client is dead.
Because it is against the order of conviction.
We will not assume that the client is dead. Unless you have some information that the client is dead on this ground.
Yes, what happens, Your Ladyship, that even if the applicant or the petition is granted bail, the client in span of 6 months they at least give us a call also. But this petitioner is never even called.
Client has fled away. So you will argue the case. If you will not argue, I will appoint an amicus for argument.
Then Your Ladyship, I need to be prepared because there are some technical aspects in this because he had taken the ground of lunacy. And he presented his applications also, 3 documents from RINPAS, which the magistrates did not consider properly. So I have to be prepared on those points on legal aspects, Your Ladyship.
He was in government service.
Initially.
So setting aside of conviction will have a very serious bearing.
No, but then he took VRS. He took VRS because he was lunatic. He was lunatic and his mental capacity.
When did he take VRS?
Before this judgment only, before this case and everything. It's mentioned, Your Ladyship.
इसका LCR है?
एक बार हम भी LCR वगैरह देख लेते हैं, Ladyship. But just not today also will do it for me,
Not today means only tomorrow.
Next week, Your Ladyship, I will say, if at all possible. Just praying for next week.
Criminal Revision number 36 of 2019. Where is the opposite party? Counsel for the petitioner is present. Nobody appears on behalf of
The state.
the state. Counsel for the petitioner has submitted that the petitioner had taken a plea that he was lunatic at the time of the occurrence. That's right?
Yes. He had taken this plea.
The learned counsel seeks adjournment to go through the records received from the court concerned. She submits that the matter be posted next week, post on Thursday next,
Okay.
under the heading for final disposal.
Item 15, Criminal Division 39 of 2019.
Nobody appears on behalf of the petitioner. This petition has been filed for the following relief. By order dated 6/8/2019, a report was called for from the concerned court, and a report with regard to the status of the case, and a report dated 28/8/2019 has been submitted by the concerned court. The report indicates that till 28/8/19, 3 witnesses out of 8 charge-sheeted witnesses were examined, including 2 doctors and the case was expected to be disposed of within 9 months. Considering the report and the fact that nobody is appearing for the petitioner, this petition is dismissed on account of non-prosecution. Counsel for the state. OP number? 2. क्या हुआ ट्रायल का? नहीं पता.
Trial final conclusion.
हो गया है?
Almost complete. Final argument.
We do not know. आपको इतना तो information होना ही चाहिए ना. Exact information. You are also confused. चल.
Item 16, Criminal Division 47 of 2019.
Petitioner. Who is for the petitioner?
Karnath Tiwari. Rajiv Kumar. Bhanu.
What is the present status of the case? Yes? Tell us what is the present status of the case?
Status नहीं आ रहा था.
किसमें नहीं आ रहा था स्टेटस? 2:15 बजे स्टेटस बताइए. 2019 का फाइलिंग है.
इंफॉर्मेट की तरफ से
इसमें एक IA भी फाइल हुआ है 4856. चार्ज भी फ्रेम हो गया था. The counsel is Mr. P.P.N. Roy. Mr. P.P.N. Roy has been appearing in this case. There is no interim order. Status बताइए second half में.
Item 17, Criminal Division 56 of 2019.
Yes, petitioner.
In this case, I am appearing on behalf of OP2 wife.
What happened in the case?
Well, this case arises out of DV Act, and certain direction has been given by the concerned court below, and that has been confirmed by the appellate court. If your lordship kindly see the order dated 8/2018, that order has been passed by the magistrate court directing the petitioner to pay rupees 25,000 maintenance and rupees 5 lakhs for compensation and Sridhar, as well as the equal share of.
What is the present position? What is the present position?
The present position, as per earlier order, 5 lakhs has been given to OP. So for other matters is that there was interim protection to the petitioner, and he is the director of the 2 companies that has come in the improved orders also, Shardul Auto and Shardul Infrastructure. Shardul Auto Works Private Limited and Shardul Infrastructure Private Limited. And there is also a minor child who is school going.
What is the quantum of maintenance fixed?
25,000.
That was under 125.
No, DB Act section.
Under DB Act, but no maintenance fixed under 125.
In maintenance case, she is getting only 100 each, 1,000 each, 2,000 for both.
While passing the order under DB Act, the amount has been considered
Considered, madam.
and adjusted.
Yes, madam. Madam, kindly see the orders. Page 2 of trial court judgment degree agent. And there is also a DI order. As per DI order, domestic investigation protection officer's order, there is torture as well as harassment from the side of the petitioner. We are permitted to read second page of the court below order.
Why is petitioner absent? Mr. Rajiv Kumar.
So many lawyers not appearing, it is confusing. Actually, who is the concerned lawyer? Mr. Kashyap also was there, and there are other advocates 5 to 6 advocates.
उनके चेंबर से कोई ना कोई तो आया ही होगा ना कोर्ट में. मिस्टर A.K. कश्यप का नाम है. अनुराग कश्यप का नाम है फ्लैश.
हमारा खाली इतना ही प्रयास है कि आज भर के लिए अगर नहीं आते हैं तो नॉट टुडे कर दिया जाए. कभी भी रखेंगे तो हम कर देंगे.
नहीं आते हैं, ऐसा तो नहीं होगा कि उनके यहाँ से कोई नहीं आया होगा.
नहीं आए तो
अगला डेट में फिर कोई नहीं आएगा, इसीलिए उनका प्रेजेंस जरूरी. उनको पता करते हैं, सेकेंड हाफ में हम लोग देखेंगे. नहीं आते हैं तो विल सी व्हाट इज टू बी डन. आप सेकेंड हाफ में घर जा रहे हैं?
नहीं.
हाँ तो बस तो आ जाइएगा. इट्स गुड दैट यू हैव मेनी केसेस. भगवान से सुपर शाम बनाइए कि इतना केस हो कि सांस लेने का फुर्सत नहीं.
जितना जरूरत हो उतना ही होने से बस ठीक. उससे अधिक
और उतना नहीं हैंडल हो रहा है तो 2-4 बढ़िया जूनियर रख लीजिए.
देखिए मैडम, हम जितना भी कमाए 6 फीट लंबाई से अधिक यूज नहीं करते हैं. 3 मीटर से अधिक कपड़ा नहीं यूज
तो
करते हैं.
अपने जूनियर्स को
से ज्यादा नहीं खा सकते.
अपने जूनियर्स को ट्रेन करने का तो काम है ना. यू आर सच ए गुड काउंसिल एंड सो मेथोडिक. यू आर एब्सोल्युटली मेथोडिकल. That I know for quite some time. You never appear in the court without having instructions, invariably. तो 2-4 junior को train करिए.
I only try at my level best to submit before your lordships and appear and to also appear each and every case.
That's nice. You train a few juniors also. Call करिए.
Item 18 Kiran CKC of 2019.
That your lordship is measuring me in such a way.
Of course, I have great regards for you. I have known you for such a long time.
More than 30 years, I think.
More than
so.
30 years.
Yes.
For what?
File missing.
For what?
My file is missing.
Your file is missing. फाइल कैसे मिस होता है? How do you miss the file? Client has paid you the fees. You can't miss his records. आपका क्लाइंट सुन लेगा तो सोचिए क्या सोचेगा आपके बारे में. You have got the records, madam. You also don't have the records.
Input order is with me, my lord.
The learned counsel for the parties are present. Who is for OP number 2? Petitioner and state are present. Nobody appears on behalf of opposite party number 2. The learned counsel for the petitioner submits that he has misplaced the file. Office is directed to provide a soft copy of the records of this case to the petitioner at the following मेल आईडी अपना दे दीजिए, मेल आईडी / फोन नंबर, ठीक है. पोज दिस केस ऑन नेक्स्ट थर्सडे. उस दिन टाइम मत मांगिएगा, टाइम नहीं देंगे. एलसीआर इसमें मंगाया गया है क्या? नॉट रिक्वायर्ड एक्चुअली. आर यू अपियरिंग फॉर ओपी नंबर 2?
Item 19, Kinonian 70 of 2000.
The petitioner has come against the order of discharge. Now charge has been framed, was tried will be at liberty to take
The
all these
learned counsel for the petitioner has submitted that the stage of the case has changed and therefore he does not want to press the present petition. He submits that liberty be reserved with the petitioner to take all the points at the stage of trial. Learned counsel for the opposite party has no objection to the prayer made. Accordingly, this revision application is dismissed as not pressed. Liberty is reserved with the petitioner to take all the points which may be available to the petitioner under law before the learned trial court, and dismissal of this petition will not prejudice either parties. इसमें खाली लिखिएगा ना, प्रेयर जो था पूरा कोट करने का जरूरत नहीं है. They have challenged the order refusing to discharge.
Dismissal is not possible.
Dismissal is not possible.
So what? Password case item 8, Conversion 585 2019 and log of item 9.
Yes, petitioner.
Item 8 and 9.
सप्लीमेंट्री हम फाइल किए थे.
कब से कस्टडी?
वो जो मिस्टेक हो गया था हमको बोलने.
कस्टडी बताइए.
कस्टडी 9 मंथ.
9 months.
16/1/22 से जो है सर्टिफाइड कॉपी ऑफ द ऑर्डर लगा हुआ मेलोड सप्लीमेंट्री.
सप्लीमेंट्री लगा है 16/1/22 से
16/1/22 से 1/9/22. 6 महीना तो हो गया.
हां 17/22.
सजा कितना?
सजा 2
17/10/22 को
कोविड बिल मिला है.
बेल मिला है. तो 16/1/22 से 1/9/22 क्या चीज है?
ओरिजिनल बेल ग्रांट हुआ है जो 19/10/2022 को. 10 months.
ठीक.
उसके बाद जो एक्सटेंड
उसके बाद एक आध दिन लगा होगा.
उसके बाद एक्सटेंड कंटिन्यूअसली होते आ रहा है.
That's right. अभी का कॉम्प्रोमाइज हो गया है.
कॉम्प्रोमाइज फाइल हो गया.
अच्छा, जॉइंट कॉम्प्रोमाइज फाइल.
जॉइंट कॉम्प्रोमाइज
और आया डिस्पोज भी
कहाँ है बताइए.
8596 आई नंबर.
8596.
Criminal Division number 585 of 2019. Period undergone कर देते हैं. Period undergone कर देते हैं. This petition has been filed for the
गवर्नमेंट एम्प्लॉई.
कौन?
सेकंड केस.
सेकंड केस में बाद में ये वाला तो नहीं है ना.
नहीं हो रहा.
Learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner has been convicted by the learned judicial magistrate first class Pakpur in connection with GR case number 530 of 2013 corresponding to TR number 292 of 2017 while order dated 11/9/2017 for offence under section 498 capital A of Indian Penal Code to undergo rigorous imprisonment for a period of 2 years with a fine of ₹1,000 and under Section 4 of the Dowry Prohibition Act, and has been sentenced to undergo rigorous imprisonment for 1 year and also to pay a fine of ₹1,000. He submits that the appeal against the same has been dismissed by order dated 2nd of April 2019, but the sentence has been modified with a direction to send back the record to the Court of Learned Judicial Magistrate First Class Backward to call for a report from the probation officer to consider the character of the accused/appellant and thereafter to pass the sentences against him according to the provision of law. उसका फ्रेश ऑर्डर नहीं हुआ है, फ्रेश ऑर्डर नहीं हुआ उसके बाद सेंटेंस पर. The learned counsel for the petitioner has submitted that no fresh order has been passed with regard to the sentence pursuant to order dated 2nd April 2019, and the present revision against present revision application was filed, which is pending since 2019. The learned counsel for the petitioner and opposite party number 2 has jointly submitted that a joint compromise petition has been filed in the present case. The learned counsel submits that in view of the fact that a joint compromise petition has been filed, wherein the petitioner and the opposite party number 2 have settled their dispute and are living together. They have also submitted that a child has also been born in the meantime. They refer to the किसी ऑर्डर में रिकॉर्डेड भी
स्टेटमेंट के बेसिस पर एक्सटेंड हुआ फिर अगस्त 2023.
They refer to the order dated 29/9/2023, wherein both the counsel for both the parties had submitted that both the parties are living together, and in the meantime one child has been born out of wedlock 2 months prior to 29/9/2023. The learned counsel for the petitioner has submitted that in view of the compromise entered into between the parties, the sentence be limited to between the parties, the present case be disposed of in terms of compromise. सेंटेंस तो एग्जिस्ट ही नहीं करता है, सेंटेंस तो एपेलेट कोर्ट ने सेट असाइड कर दिया, करके उसको रिमांड कर दिया था अंडर द फॉर कंसिडरेशन अंडर प्रोविजन ऑफ ऑफेंडर्स एक्ट. तो पीरियड अंडरगॉन भी कैसे करेंगे? नहीं कर सकते ना, because there is no existing sentence. It has also been stated that although the sentence was set aside by the appellate court and the matter was remanded to the trial court for consideration so far as the point of sentence is concerned and for consideration as to whether any benefit can be granted to the petitioner under the provisions of Probation of Offenders Act, but the petitioner has remained in custody during the period from 16/1/2022 and provisional bail was granted by this court only on 19/10/2022 and provisional bail and a few days must have been taken by the petitioner to furnish the bail bond. The provisional bail is expiring on
March 2024.
31st of March 2024. They submit that the present petition be disposed of in terms of the compromise between the parties. कोई objection है? The learned counsel for the state has submitted that he has no objection, particularly considering the fact that the petitioner and opposite party number 2 are living together peacefully and a child has also been born in the meantime. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that this court has gone through the joint compromise petition being IA number 8596 of 2022 and the order sheet of this court which reflects that the parties have settled their dispute outside the court and are living together peacefully and a child has also been born in the meantime. In such circumstances, in order to secure the ends of justice between the parties and to help the parties and so that the parties may continue to live peaceful conjugal life, this revision application is disposed of in terms of the compromise between the parties. That should be sufficient. This revision is accordingly disposed of. Complete.
सेकेंड केस में भी जो फॉर्मेट सेम है, वो हस्बैंड के ऊपर जो फर्स्ट अभी पिटिशनर है और उनके मामा ससुर एंड मामा ससुर क्या है डॉक्टर सन इन लॉ पर केस।
इसमें भी तो सेम ही ऑर्डर से आया है ये?
नहीं, ये अनदर केस।
भाई दूसरा केस इंसिडेंट सेम है?
इंसिडेंट अनदर
354 बी और 323 पे कन्विक्शन।
इसमें भी जॉइंट कॉम्प्रोमाइज फाइल किए हैं। 354 बी कंपाउंडेबल है। कितना दिन कस्टडी मलाई 354 बी? ये कैसे कंपाउंड?
वेल कंफर्म करते हुए इस पे हेयरिंग पर इसको रख देंगे।
ये नहीं होगा।
कस्टडी
से मतलब नहीं है ना। We cannot compromise a case beyond law. लॉ बताइए हम सब कर देंगे। लॉ बताइए ऑर्डर लेके जाइए, हमको कोई इशू थोड़े। लेकिन 354 बी कंपाउंड करने के पहले हमको वो सोचना पड़ेगा। IPC विचक्राफ्ट भी है। मिनिमम सेंटेंस भी है 3 years,
3 years.
रिलैक्सेबल भी नहीं है, तो मिनिमम सेंटेंस से तो कम हो ही नहीं सकता अंडर एनी सर्कमस्टांसेस।
इसमें जो कंप्रोमाइज फर्स्ट केस में हुआ 60 में लग गया।
नहीं कर सकते हैं ना, लॉ दिखाइए ना, आपको बोल रहे हैं लॉ दिखाइए, आप हमको ऑर्डर लेके जाइए, सब चीज़ सेटिसाइड कर देंगे। मिनिमम सेंटेंस है 3 years, इसमें ये भी नहीं है एट द डिस्क्रिप्शन ऑफ द कोर्ट। शो मी सम लॉ। आप क्या प्रोविजनल बेल पर हैं?
ओरिजिनल बेल पर है जो फर्स्ट पिटिशनर जो फर्स्ट केस में वही इसमें भी है।
प्रोविजनल बेल कब एक्सपायर हो रहा है?
31/3/2024 में।
आपका आईए फाइल हुआ था फॉर एग्जेम्पशन फ्रॉम सरेंडर,
वो 2% के अगेंस्ट में
Appellant 2 and 3 के लिए।
2 and 3, और पिटिशन नंबर 1 का
ऑलरेडी कस्टडी में था इन द फर्स्ट केस में, फर्स्ट रिवीजन जो था,
हाँ उसमें
कस्टडी में थे, उससे इसमें रिमांड हुआ।
ये जो 9 महीना का कस्टडी हमको बताए हैं उसी केस में कस्टडी है कि इस केस में कस्टडी?
दोनों केस में सेम है, लेकिन उसमें 9 month कस्टडी वाले के लिए अप्रैल का सेंटेंस है मैडम।
12/2/2022 के लिए।
कौन से ऑर्डर से 31 मार्च तक एक्सटेंड हुआ है
वो जो है
बताइए।
19/9/2023 को दोनों के साथ में चल रहा था, जो इसमें ऑर्डर दोनों के
19/9/2023 का इसमें कोई ऑर्डर नहीं है।
फर्स्ट केस
साथ में चल रहा था, लेकिन ऑर्डर भी तो होना चाहिए ना।
दोनों पे एक साथ
दिखाइए।
ऑर्डर आ रहा था।
इस ऑर्डर की कॉपी इसमें लगाइए, होना चाहिए ना, क्योंकि ये तो डिस्पोजल हो गया। बाकी दोनों कौन है जिनका एग्जेम्पशन हुआ था? ये तो पिटिशन नंबर 1 का प्रोविजनल बेल हुआ
जी,
और पिटिशन नंबर 2 and 3 का
उनका
एग्जम्पशन फ्रॉम सरेंडर।
एग्जाम्पशन पर सरेंडर अलाउ हुआ है मैडम।
अच्छा, आप प्रेयर प्रोविजनल बेल के लिए किए थे कि बेल के लिए?
बेल के लिए।
दैट आईए मस्ट बी पेंडिंग।
पेंडिंग
आईए
5846
5846
5847 बेल के लिए। 5847
5846। केस एडमिट नहीं हुआ है, आप वाइफ की तरफ से हैं। इसमें काम बेस्ट यही रहेगा कि इसको अभी पेंडिंग कर लेते हैं, क्योंकि अगर मान लीजिए बीच में गड़बड़ हुआ देन यू अपोज, राइट?
इसको बेल देते हुए जो पेंडिंग रखेंगे।
आइए डिस्पोजल करके बेल कंफर्म कर देते हैं
जी मैम।
और शांति से रहिए, समझ
जी
गए ना?
जी जी।
अभी हम हैं यहाँ काफ़ी दिन। बेल कैंसिलेशन फाइल अगर हुआ तो कैंसिल कर देंगे
जी
और उसके बाद बस फाइनल डिस्पोजल कर देंगे, फिर आपको पता है क्या क्या हो सकता है। ठीक है। Criminal Revision number 499 of 2022 with IA number 5847 of 2022. The learned counsel for the parties have submitted that the petitioner number 1 and opposite party number 2 are living peacefully, and a child has also been born out of wedlock. The petitioner number 1 is on provisional bail, which is expiring on 31st of March 2024. And so far as petition number 2 and 3 are concerned, they have been granted exemption from surrendering before the learned court. The learned counsel has also submitted that a joint compromise petition has been filed in the present case. Considering the learned counsel for the petitioner submits that the provisional bail be confirmed and the matter can be heard on a later date. इसका records आया है? He has also submitted that records have been received from the learned court and he has to go through the records of the court concerned, right? Considering the nature of offences under which the petitioners have been convicted, this court is of the considered view that some hearing is required to be done before taking a call with regard to compromise between the parties. Accordingly, this case is admitted for final hearing. The IA number, कौन सा joint compromise petition आपका?
5846.
IA number 5846 of 2022 will also be taken into consideration at the time of final hearing. However, considering the aforesaid facts and circumstances, and that particularly that the petitioner and opposite party number 2 are at present living peacefully, the provisional bail granted to the petitioner is hereby confirmed on the same bail bond which has been furnished by the petitioner. It is also directed that petitioner shall furnish a copy of the Aadhaar card and नहीं, subject to the condition that आधार कार्ड वाला condition था उसमें, subject to the condition that the petitioner shall furnish a copy of Aadhaar card and his phone number before the learned court below within a period of 1 month from today. Accordingly, IA number 5847 of 2022 is disposed of. It is further observed that whenever this case is taken up for final further hearing, the parties should file necessary affidavit regarding the present position of the relationship of petitioner and opposite party number 2. Petition number 1 and opposite party number 2. Admit करके इसको the rule is made returnable. अगला साल जून का डेट दे दीजिए. To be posted under the heading for hearing. Be in touch with your client. उस दिन ऐसा नहीं बोलिएगा कि पता नहीं, जानते नहीं.
Last 2 months से हम शुरू नहीं पेमेंट देंगे. Last 2 months से का कॉन्टैक्ट नहीं है.
19th June 2025.
Item 20, revision 77 of 2019.
Yes, petitioner. Where is the petitioner? This is refusing to discharge. What is the present status of the case? It's under 376. The case was fixed for evidence on 14/8/19 itself.
5 witnesses already examined
5 witnesses already examined.
in the year 2019.
You have for OP number 2. Learned, nobody appears on behalf of the petitioner. This petition has been filed for the following relief. Learned counsel for the opposite party number 2 has submitted that 5 witnesses have, that the trial has progressed and 5 witnesses were examined as back as in the year 2019. You are for the state?
Yes, sir.
Okay. 5 witnesses, उसके बाद कुछ नहीं? अच्छा. Considering the fact that the trial has progressed and nobody is appearing on behalf of the petitioner, this petition is dismissed for non-prosecution. 376 में discharge. फिर से लिखिए. Criminal revision number 77 of 2019. Counsel for the parties are present. Counsel for the petitioner seeks permission to withdraw this petition and he submits that liberty may be reserved with the petitioner to take all points before the learned trial court. He submits that the trial has progressed. After counsel for the opposite parties have no objection to the prayer made. Accordingly, this petition is dismissed as withdrawn. Liberty is reserved with the petitioner to take all points before the learned trial court, and dismissal of this petition will not prejudice either parties.
Thank you. Thank you. Item 21, criminal revision 98 of 2019.
Petitioner.
For 2 weeks time. Conviction matter है. petitioner का existence के विषय में पता नहीं चल पाया.
वो नहीं पता चलेगा. बेल मिल गया ना petitioner को. अब कहाँ से मिलेगा आपको? उसका कोई अता पता नहीं मिलेगा. आप नहीं बहस करेंगे तो amicus अपॉइंट कर देंगे हम.
एक 1 week का टाइम दे दिया जाए, हम पता करके हम फिक्स कर दिया जाए.
ठीक. Counsel for the petitioner is present. Nobody appears on behalf of opposite party.
एडमिट नहीं हुआ. LCR कॉल हुआ.
LCR आ गया है ना? एडमिट नहीं किया जाए ना?
नहीं एडमिट नहीं किया गया है अभी तक.
नहीं, कोई जरूरत ही नहीं है एडमिट करने. रिवीजन में एडमिट करना कहाँ जरूरी है? Counsel for the petitioner prays for adjournment to go through the records received from the court concerned. Post on next Thursday.
Item 22, criminal revision 196 of 2020.
report was called for on the last day.
It is
Extension
successful.
of time was seeked by the
Mediation report, mediation is successful. Some more time.
on the last date, Your Lordship. The prayer was made.
Then what happened? You must be knowing about the
Actually, Your Lordship, I tried to call, but she is suffering from cancer, so she could not contact. Let it be on the next Thursday, Your Lordship, I'll apprise the court. There was some progress in mediation.
Your Lordship, the mediation for installments have already been paid by the
Criminal Revision number 196 of 2020. Counsel for the petitioner submits that the mediation has been successful. However, such report has not yet been received from Jharkhand from Jhalsa. Office is directed to call for a report from Jhalsa with regard to the result of mediation. Post on next Thursday. Let this order be communicated through fax to Jhalsa.
Leadership may make a small request to leadership. Leadership serial number 14 touches with the leadership on these two fix on Thursday. Since I'm not in touch with the clients and leadership, just requesting for the scanned copy of the LCRs. I checked it, it's little bulky. So if possible, leadership, I will pay the cost also if necessary, because I need to give proper assistance. This is a scanned copy of the LCR. If may be provided.
हम लोग के पास क्या स्कैन कॉपी का
और the
फोटोकॉपी आता है
photocopy.
कि स्कैन करके आता है? वहाँ से स्कैन करके फोटोकॉपी भेज देते हैं. ऐसे स्कैन सॉफ्ट कॉपी नहीं है.
I will pay for the photocopy charges also if at all leadership pleases to order for that, because it is not possible.
Serial number कौन सा है?
14 leadership. Criminal Revision 36 of 2019.
Serial number 14. At the request of the counsel for the petitioner, let a scanned copy of the records received from the court concerned be forwarded to her at the following email ID. Scan करके भेज दीजिए. भेज सकते हैं. नहीं, जो हमारे पास आया है उसी का स्कैन करके दे दीजिए. यहाँ पे नहीं होता स्कैन, नहीं उसका करवाना, LCR का करवाना.
If at all a photocopy is also provided, I will pay for the cost. I will deposit the cost also.
स्कैन करके दे दीजिए. क्या है इसमें जो आया है? ठीक है.
I will provide my own.
वो दे दीजिए. Needful be done by Tuesday.
If by this, then we can utilize your leaderships. I understand.
You can go and get certified copies. That would be better.
By Tuesday leaderships. All right. Thank you.